Welcome to That Annuity Show, the podcast that will make you an expert in explaining annuities to your clients. Give us 30 minutes each week and we'll shave hours from your client presentations. Now, here's your host, Paul Tyler.
Hey, this is Paul Tyler, and welcome to another episode of That Annuity Show. Ramsey, how are you?
All good.
Hey, good. This is the first episode after we had a really cool event in Hartford talking about the future of retirement products, planning, and advisors. We called it the first annual Retire Tech Forum. Wish you could have been there, Ramsey.
Yeah, me too. I was out in sunny California, so I was in a nice place. But you were nice enough to FaceTime briefly, so I could say hello to all my friends there. So looking forward to the next one.
Yeah, it was a great discussion. We're just literally cutting through the recordings we did on. We did stream it, and we'll cut the recordings up. And I think, Ramsey, it probably makes sense to wrap some of these up as episodes. Maybe there'll be special episodes, and we'll push them out to people so they can, hear parts that we're not. Now, the really cool part was we had maybe 85 people there in person in Hartford, Connecticut. This was not Las Vegas. It wasn't New York City. It was Hartford, Connecticut. I like Hartford, but it wasn't. This may have been on some people's bucket list, but Laura had people raise their hand for everybody who'd been on one of our shows, and like half the room had been on them. I mean, I think we've really created an interesting community here.
Absolutely.
Yeah.
Absolutely.
So today we've got two great guests. Okay. One of them has been on the show before, been a great friend, and I personally crossed paths with him many times. I'm going to put a big warning label on this episode. Okay, if you're a consumer, stop. Episode. I'll keep our compliance people, happy. We're really intending this discussion to be for producers' use only. However, I think we'll cross into some issues that are probably important for consumers if they wanted to know, but I'll just leave it at that. And if you saw this thing marked as explicit, that's why. A dangerous episode. So I'd like to welcome two terrific individuals, okay? And first of all, Mr. Harry Stout, who almost doesn't need an introduction if you've been in the independent insurance space. Harry is an industry veteran with over 25 years of experience in the U.S. and abroad, and his colleague and hopefully friend, Bruce Saul.
We're friends.
You're friends. Who is an attorney with significant industry and business experience in our sector. He's played some leading roles both in private practice and in legal departments at insurance carriers. So welcome, Harry and Bruce.
Thank you.
Glad to be here. Thank you, Paul.
Yeah. Harry, anything you'd want to add in terms of what else you've done? I mean, I'd say that introduction doesn't do you justice. You're an author, you're a speaker, you've led companies. What else have we missed here?
Yeah, I think the key for today, Paul, is that I have been looking at industry pain points for consumers in the annuity space, and we'll talk more about that today. But I think my focus has been on consumers. I've written a book about today's annuity products to help educate consumers and to improve the knowledge of what annuity products are all about. And you've had a number of episodes on your podcast about the increase of the use of annuities, what we see in the future. So my focus has been on the consumer and how can we make it a better experience and process for them.
Oh, this is a great setup for it. And Bruce, just tell people a little bit more about what you've done and your the roles you're playing in the business.
Great. Well, Paul, thank you for the invitation to be on the show. It's a pleasure. You gave a great introduction. The only points I would add is also in my career, as I moved along, I had an opportunity to be in the public sector. So I served as a regulatory policy analyst in the Federal Insurance Office. That's a federal office created under Dodd-Frank, and it is housed in the U.S. Treasury Department. So I was with that organization for a number of years and concentrated mainly on life insurance and annuities, the industry and its products. So in that role and others, I do have a lot of direct experience with fixed and variable annuities and life insurance, also disability income and a fair amount of long-term care insurance. And I also wanted to add, for purposes of today's discussions, for a number of years, I was the chair of the Life and Health Insurance Guaranty Corporation of Maryland.
Oh.
And later on, I served on the board of the Minnesota Guaranty Association.
Okay, Guaranteed Association. So you kind of know where we're going to head at this point. And
a little bit, yeah.
Yeah, pain points. Harry, okay, I've been in a bunch of different roles. I'm telling you, as marketing role, this is a challenging topic. We talk about guarantees day in, day out, and then somebody says, "Well, explain the guarantee to me," and all of a sudden it feels like I'm moving my lips and no sounds are coming out.
Well, no, I can see that. I mean, when you look at what we sell in the annuity business, right? The key aspect of what we're selling is guarantees, and then the first question that consumers have is, well, who's guaranteeing this product that I'm buying? And naturally, we talk about the insurance company because the insurance company, the issuing annuity company, life insurance company that you're buying from, that's the primary source, financial, if you will, backup for the product that you're buying. Many times we talk about state regulation as being important. We say, well, insurance companies are regulated very rigorously on a state basis. Their solvency is looked at. And that's a second item. Thirdly, sometimes we talk about, all the major annuity companies that are out there have third-party financial strength ratings. And we can talk about that. We can talk about those indeed. But then there's this subject of guarantee funds and the existence of guarantee funds. And so Bruce and I wrote an article for ThinkAdvisor on letting the guarantee fund Genie out of the bottle. And I started, in the work I've done over the last several years, I look at ways in which we broaden annuities. I mean, and you all have talked about what's happening with the Secure Act. We've got new groups of individuals selling these products. We've got the RIA community beginning to take a look at guarantees. We have defined contribution plans beginning to offer guarantees as part of what they do. So guarantees are more and more appropriate. So in the industry, we have something called guarantee funds, but we really are not able to talk about them. We're unable to discuss them. Yet they are in that pecking order of what stands behind potentially that product if the issuing insurance company has a financial issue and is unable to pay the liabilities for the liabilities that they're selling. So the question is, why? What are guarantee funds, and why can't we talk about them? And what are the prescriptions against that?
Yeah, well, so I tell people this. You walk into a bank. Boy, before you even open the door, there's the FDIC sticker on the window.
Yep.
Guarantee, guarantee, guarantee. Now, insurance company, it's almost like the reverse of don't ask, don't tell. Okay, if you ask, I can tell. Right?
Yeah.
So why? First of all, what's the history? Like, why can't we talk about these state guarantee funds? Anybody? I don't know the answer.
Yeah, I can give a little bit of color there, Paul. Really going back, there are laws on the books in every state and the District of Columbia, and I don't want to get overly technical in this forum, but I do think I'd like just to explain what the law actually says, because I think that's kind of at the heart of this entire discussion. So every state has a guarantee association set up to protect policyholders, as Harry said, in the rare case when an insurance company fails. There are multiple provisions in the law to accommodate this framework and this goal of giving that protection. But in almost every state, there is also a prohibition on advertising. And when you look at the words, it's interesting that there is really no wiggle room at all for any kind of discretion around the subject. The law prohibits any person. Person includes an insurance company or a producer for making any statement, written or oral, that uses the existence of the guarantee fund for purposes of selling or inducing the sale of a product. So if you think about that for a moment, the way that's drafted, it doesn't, for example, say that a person is prohibited from describing guarantee funds in a deceptive manner. It's stronger to the point of saying you can't even mention the existence of the fund. Now, as I indicated, the prohibition is on using the existence for purposes of sales or inducement, but the practical problem here, these conversations are happening when consumers ask questions. It's not a surprise that there is a sales process involved. So it's very difficult for the insurance company or the producer to have any comfort that with hindsight, that can't be characterized as a conversation that was related to a sale. So I've always thought as a lawyer and a compliance advisor, effectively, this stifles any discussion between the consumer and the company or the producer about this basic protection. That's the gist of it.
So I've got a question about whether or not you think that that broadly industry participants kind of understand the structure of the funds and their limitations. So Paul drew a comparison to FDIC, but I think maybe a good thing to do here is to talk about what's different about each of the various sort of backstops in different parts of the financial services industry. All have not just different dollar limitations, but they have different sources and backing. Like how are they different? Because I think one of the inherent risks with the discussion is that either a producer might not know what the differences are, and even if they do, they may not convey the differences as well as they might to a consumer. So let's start with how are those various entities different with respect to the coverage that they provide?
Yeah, that's a great question, Ramsey. A couple of key differences. Thinking about consumer experience or producer experience, just looking at the landscape. Some of the known backstops are probably the best well-known is FDIC, the Federal Deposit Insurance Corporation for banks. As Paul indicated, it's clearly stated in a bank lobby that FDIC coverage is available. The same for SIPC, the broker-dealer protection regime at the federal level. I think some differences with the state guarantee association system, I'd probably boil it down to two that are most important. One is that the state guarantee funds are not backed by any governmental entity. The states, and this is a great question, Ramsey, you raise a very good point about the potential for misunderstanding. A lot of people are familiar with FDIC. They know that the federal government stands behind. But in our state system, with state regulation, it's evolved differently, and there is no implied or explicit or implied governmental backstop. The liabilities of the Guarantee Association to cover the obligations of the insurer are funded by industry members, all of whom must, by law, belong to the State Guarantee Association. So that's one, no governmental backstop. And two, the state system is not pre-funded. What happens if a life insurance company is in trouble, becomes insolvent, then in the insolvency proceeding after the fact, the Guarantee Association collects assessments from the members to pay the obligations. Okay. So kind of high level, those are some of the key differences.
Yeah, and Bruce, tell me if I'm wrong on this, because this is a hard subject to kind of wind your way through. The structure seems to be similar state by state, but there are some variations for each state fund, correct? I mean, I'm not sure if are they material, are they not significant in your mind?
That's another interesting and important point. There are differences. Again, many in the audience are of course familiar with the state guarantee, the state regulatory structure. There's an organization, the National Association of Insurance Commissioners, that adopts model laws. So the way the guarantee fund rules work is the NAIC, the last time it took a full kind of look at these coverage limits was back in 2009. So under the model, there are limits established for life insurance benefits, long-term care, disability, and annuities. And the limits are generally $300,000 for life insurance, death benefits, long-term care, and disability. For annuities, it's $250,000 in present value. The states have made good progress in the past 10 years in gradually reacting to the model law and actually bringing those levels into compliance with the model law. But there are still some differences. Some states are higher, some are lower, so it's not uniform. But it's a bit of a patchwork, but it has improved pretty significantly the past 10 years.
And Paul, one of the things for me, looking at it as I've looked at this from a consumer standpoint, and many producers, obviously, they're not allowed to mention, nor do they mention, the existence of guarantee funds as some sort of inducement to buy the product. Yet when the consumer gets delivery of their contract, depending upon the state, there's going to be information about the guarantee fund that all of a sudden shows up. And that's added to the contract at that time. So when you go through that, you say to yourself, what's happening here, and where did this come from, and why didn't you talk to me about this? So it seems to be a very convoluted process that is not as focused on the consumer as it could be.
Yeah. Now, it's somebody who's outside the industry would say, "Oh my gosh, Harry, Bruce, this is a mess. You got 50 different states with all but it's actually worked remarkably well, right? Like, yes, there have been, just as in the case of thrifts or savings banks, going into receivership, we've had insurance carriers, but I think the track record is pretty good, state by state, right? Am I wrong? I think it's functioned well.
I agree with that. There are different schools of thought, Paul. That's a factual question, but
yes,
as happens, there are different views. I will tell you that there have been some federal government studies and reports, and some private industry studies that have been critical. And as usually these types of reports generate after a well-known insolvency occurs. Some criticisms include concern that the system may not be adequately funded if there was a major or a series of insolvencies, kind of a financial panic type environment. My personal opinion is that the system has functioned fairly well in terms of the number of insolvencies over time, going back about 50 years. So these insolvencies aren't unheard of, but they're not common. That said, there have been some significant failures with millions of dollars and thousands of policyholders, such as Executive Life of California, Executive Life of New York, Conseco. So that's, like I said, different views on the track record, but I don't think that there's I think it's a fair statement that in terms of protecting and providing the support, the system has worked reasonably well.
Yeah, and I think even those companies you've mentioned, knowing what I know about them, which is not, it's what I've read and what I've seen or heard, is I'm not sure not talking about it. I'm not sure that if they talked about the Guarantees Association, if that would have had any impact on the trajectory of those companies. Is there a policy? I don't know. Is there Ramsey? Can you think of a good policy, or Harry or Bruce? Is there a good policy reason to keep this, this thing not at the forefront of a client discussion?
I think that if you look back, and this goes back, and Bruce, you can correct me, maybe even 20 years, there was concern on the part of some of the more financially secure companies that there were companies out there selling products that weren't financially supportable, and that there was the potential for those companies to be in precarious financial shape, and the industry was going to have to step in and pay, if you will, guarantee fund assessments to cover for the liabilities that they've written. I think over the last 20 years, as we've improved state regulation, as we've gone through how companies can invest, reserve, a lot of these potential areas where you have outliers has been reduced. So when you look at it, I think that's a concern. And just another overall factor here for me. If I'm a consumer buying a product today, a financial product, I mean, or any of us, we're buying a consumer product. We look for a J.D. Power Association rating. We want to know what the financial strength rating of the organization is. We want to know what their other financial strength, any other aspects of that product that I'm buying, the guarantee that I'm purchasing. So it seems there's an incongruity here between what in a modern age, what a consumer would want versus what is available and what is disclosed, and it just seems to be a really strange anomaly that goes back over that's been created for a number of years because of a number of different reasons, and maybe it's time to take a look at it and streamline it and make it more effective for the parties involved.
Yeah, Ramsey, talk, how many times have you done the dance around the guarantees? You know, the
I don't talk about
question. Yeah, but like I'm a client with you, and I'm sure you, and I'll share with my discussions, which is, well, are these really backed by anybody? How do you talk about guarantees without talking about the not leading to a guarantee association and end up with a satisfied client?
Is that for me?
Yes, for you.
My focus has always been on the companies themselves. But I actually want to just one of the things that I want to sort of maybe shift gears a little bit on here is just going back to the question of why this is a difficult thing to talk about and why there might be concern on the part of regs or others. I mean, one of the things I've always wondered is what does the user experience look like? Like, so in the case of the FDIC, right, if a bank is in trouble, the bank is taken over by the FDIC overnight, like teams of people come in, and depositors don't know the difference. Like the next day they come in, they can take money out, they can do, like it's a very sort of seamless behind the scenes process. And and that may not be the reality of SIPC or guarantee funds. I don't know what the reality is per se. I'm just saying like there's not just the financial backing element of it. There's user experience and timing are sort of another differentiating issue potentially between these various backing entities. So all those things are part of the discussion, and without sort of being able to sort of articulate those differences in a very sort of meaningful way, I can see why there's reticence, right? There's reticence to sort of to put right to extend any kind of warranty over what it might look like without actually knowing.
Yeah, Ramsey, I think that's a point very well taken, and one of the public policy rationales Harry articulated very well, one of the points, but the other that I've heard raised, and I think it's a important point to focus on, is the differences among the various systems, and comparing a bank certificate of deposit with other products. It is sometimes the case that there's more complexity with annuity insurance products, relatively speaking. I still, however, come back to take a case with a fixed annuity, a $50,000 account value, a life insurance policy, $100,000, whether it's term or permanent. Those amounts are clearly under the state coverage limits. And I don't think that those are so complex that it's difficult or straining to have a conversation about them. More complex products, take a structured settlement annuity, maybe a group annuity. Those are more difficult to explain, but those aren't the sort of bread and butter type sales in the business. So I acknowledge the point, but I don't know. I keep coming back to the wording of the statute is so prohibitive that not even be able to respond to a question is a very tough standard, I think, in today's consumer.
Understood.
Yeah.
So I guess my question is sort of, if were something to happen, what would be the experience? So in the case of FDIC, like the next day, like you just don't know the difference. The U.S. government steps in, right? What does the experience look like? I mean, you said you had a management role in two different funds. So, like, what is the experience of the person? If somebody is has a policy that ultimately ends up being sort of backed by the guarantee fund, what is the typical experience they would have in terms of when they would get their money back? Like, is it measured in minutes, hours, days, weeks, months? What does that look like? Because that's an important part of sort of the differentiation there.
Yeah.
And just as a matter of setting expectations in the right place.
Right. Yeah, the experience is going to be along these lines, and of course it'll depend on the complexity of the company that failed and the complexity of the insolvency. But there's a whole kind of industry that's established to deal with these insolvencies when they happen. So the consumer will learn about the insolvency usually from the company or the receiver, and there's consternation. But there'll be some communication about the plan, and typically, especially for a relatively simple insolvency, the associations arrange, or with NOLGA, if it covers more than one state, arrange for another carrier to come in and pick up the business. So there's going to be at least the delay of explaining what's going on, and remember, this is under a state court proceeding, so it's not an immediate turnaround. So it's going to vary, but I think if you look at some of these larger insolvencies that are complicated, it can be months or years before there's full resolution. Other cases, it's not that long, but it's not an immediate turnaround.
And Ramsey, one other thought I'd add to you is, even in the case of FDIC coverage, if you get people with large account balances that are, if you will, beyond the FDIC coverage, that's an issue. And I think the same thing applies in the case of insurance insolvencies. I mean, I think, and Bruce, correct me if I'm wrong here, but my experience is typically the administrators do everything possible to make sure that claims within the limits are paid and cash flows as quickly as possible. They do their best to do that. But if there are individuals with balances or accounts that are in excess of the amounts involved, I think that's problematic. I mean, that's one of the issues that I do think is problematic. And maybe that's a consideration that the consumer should have when they purchase, that maybe they don't purchase more than a certain amount from a certain carrier, because there are limits on coverage. The same way that people will take their bank deposits and put them with, and again, I'm not an expert on FDIC coverage, but it's, I think, on a per account basis. So people try to limit their accounts and spread their potential liability to a number of banks, so that if something does happen, if there's a wholesale impact of the banking community, they're covered by FDIC insurance. And I think that's another issue when it comes to guarantee funds is, you ought to know that for these larger amounts involved, if you have amount with an annuity or a life insurance policy that's in excess of these limits, there's potentially a concern there.
Yeah, I agree. The point's the same for FDIC or in the state. The Guarantee Association is only obligated to cover the amount up to that limit. So you're right. If the consumer has life insurance benefits, say, even with the same company, either one policy or more that exceed that limit, they don't have that protection.
Yeah. Now, I've had these questions come up in context with, guaranteed income riders on products. It's interesting. We've got, chat on our website, and I think over the last 2 years, I probably had more direct contact with customers and with agents on some of these topics than I ever had all the years before, which is good. MIGAs, though, seem to be really driving the conversation. I think it's given the interest rate environment we're in, I just see this issue coming up and up and up. Like I'm looking at Annuity Rate Watch right now. Harry, I can't believe the numbers, right? It's like I see one carrier, and I'm looking at the 5-year rates, offering a 4.35% interest rate. I see two more at 4.25. If you told me 6 months ago we'd be seeing these kind of rates, I would have said no. But people are going to be looking at bank CDs and MIGAs. They're going to look at MIGAs more frequently, so I think this is going to come up. Now, my approach that has worked without going down that path is first head to the balance sheet. Hey, Ramsey, where's the guarantee? It's guaranteed by our $26 billion, assets. Okay, that satisfies probably 60% of the people. Yeah, but what else? Well, here's our ratings. Okay, and then here are our Trustpilot reviews. You're going to get good service. Look at all the thousands of people who've had good experiences with us. Harry, without going there, what are the best consumer explanations that get people comfortable without even talking about this?
Well, I think you've hit on them there. I think typically you highlight the company itself, how long it's been in business, their track record of how they treat the consumer. That's primary, right? And then secondly, I think you hit on the financial strength ratings of the companies that are involved. I think Ramsey was alluding to that earlier. You, as a producer, you represent those companies that you feel most comfortable with from a financial strength standpoint and meet whatever threshold you or your organization has for the sale of those products. And different different organizations will sell different financial strength ratings. Some are comfortable selling lower financial strength ratings. Others must have a certain threshold and above that they sell. And then I talk about state regulation being the third bucket, and if guarantee funds are part of the conversation, if they're aware of them and that they've been disclosed to them, I think the conversation has to be made aware that that's another element in the overall hierarchy of solvency. And I guess I'm not trying to create Maslow's hierarchy of needs here, but it's if you think about it, you've got there is a hierarchy of solvency, and we ought to be able to describe what that is.
Yeah, and Bruce, when these laws were drafted, I guarantee you, Google wasn't even a company. Today.
Right.
Now,
oh yeah, there's no doubt about that.
So Nolga has this great website that explains this in perfect detail out there. So if a consumer says, ask Google, Ramsey, how our insurance policy is guaranteed, Nolga's site comes up. Mm-hmm. So Bruce, if I were to put us on a website, I'm not going to hold you. I'm not asking you for legal advice, but if I put on my website FAQ. Explain, how are these products guaranteed? C, and I put a hyperlink to Nolga. Am I skirting the law by doing that?
I think that is an appropriate practice, Paul. Really, it's to a point where what the law does, kind of for a moment, just aside from the issue of what the law should or shouldn't say, it clearly is intended to take the conversations and take those questions away from the company and the producer to the guarantee associations. So I think in the current environment, given the prohibition on even mentioning the existence or using the existence of the guarantee fund, it makes sense to be responsive. You don't want to be completely unresponsive. So Nolga does have good information. In fact, the way the state laws are drafted in most states, Harry mentioned at the point of delivery, there's a document that describes the guarantee fund and some of the issues we've been discussing. It says on its face that the producer and the company cannot talk about the guarantee fund, and it instructs the consumer to call the state guarantee association.
Yeah.
So what comes up repeatedly, and this is a good example, the guarantee funds do exist. That's a fact. That's reality. There is a way, the state laws understand that consumers are interested, and there is a way to have that information disseminated. The point that to me causes the discomfort and seems kind of out of sync with the way consumer protection and regulation has been going for some time now is that bar on any discussion of the subject with the company or the producer that the consumer is looking to.
So I'm curious. I saw your article, and Harry, I reached out I think about 5 minutes after to get you on here. What Bruce and Harry, what kind of response have you received from people off the article you put in ThinkAdvisor?
Actually, the folks at NOLGA read it. They posted on their website and sent it out to state regulators all around the country, which I thought was interesting.
Okay.
I think the response we've gotten was a lot of the response we got from Ramsey when we started our session today, which I don't mention this. Do you know what I mean? There's controversy, there's confusion. I don't really mention this as I should, but if you talk to people, and I've talked to probably 10 to 20 fairly large producers around the country who responded back, and what they're saying is, this is a pain point for us. This is kind of crazy. And for me, as I write about the industry, and look at what what your program has done, you highlight technology changes, expansion of product, all these things we're trying to do to make annuities more mainstream and used by more and more people as part of as a tool in their retirement planning. This is part of that equation and has to be mentioned at some point. And they're saying it's crazy for us. Why can't we say something about it? Why can't we talk about it? And if you look at it from a consumer standpoint, you have to admit it's kind of convoluted. You don't talk about it, and all of a sudden you get a document pops up when you get your contract that talks about it. So I've been kind of free as someone who writes about consumer issues. I tell consumers in my book, I've said, look, you want to know what the guarantee fund coverage is in the state that you're buying the product. You should do that. And I direct them to the NOLGA website. I've had a section of my book on that. And I think, but I can do that. I'm not selling the product. I'm just an industry observer, someone commenting in the industry. So I do that. And I encourage folks, look, as an informed buyer, you should know that this exists and that it's out there and what implications it will have potentially for you should something go wrong. And naturally, the nice thing that in our industry has been we've had very few things go wrong. And we haven't had massive numbers of insolvencies. We haven't had these issues where consumers have been hurt or in any way negatively impacted. We've had some very little amount, but not a lot. But in a day and age when we're trying to lift our game everywhere, to me, and that's why I reached out to Bruce and he and I collaborated on the article. Maybe it's time we lift this one up a little bit and let people know a little bit more about it.
So, okay, change is interesting, right? There's a pain point in the industry. Oh, it just goes away. No. My experience is it takes somebody or some group to really sort of ride that horse and make the change. Who would do this, and how would this happen?
I think one of the things going to take place, and Bruce can add here as I go through, with respect to new standards for best interest and fiduciary practices with respect to the offering of guaranteed payout options in either defined contribution plans or across the industry in all different spectrum, the whole spectrum of how we're offering these products. You would think as part of those adhering to those standards, and then we're going to have developing fiduciary standards over the next couple of years, should not this be part of that conversation? Because it is part of what, if you will, the guarantees are part of the solvency backstop for the annuity products that are sold. So you would think maybe that as part of that conversation, something would nudge it along to begin to have these funds disclosed and talked about more. That's just the thought. And Bruce, you want to add to that?
Yeah, I think those are very good points, Harry. One thing I would add, just for interest and maybe a little bit of direction, is the state of Minnesota, I believe it was in 2015, amended their guarantee fund law in an interesting way. The state retained the advertising prohibition, so the language I used earlier is still unchanged in the Minnesota statute. But the law also goes on to say explicitly that the producer may verbally explain, those are the words, verbally explain guarantee fund coverage at any time during the application process or after. That's maybe a separate conversation. That seems to me not an ideal solution because it's a little bit of a head scratcher. I can't use the existence of the fund to sell, but I can verbally explain it. But I just offer that as at least maybe some fresh thinking about the possibility of taking this very hardwired prohibition and having a little flexibility. Meaningful change, given the existing state laws, really to change the current structure is a significant undertaking because it comes back to the NAIC model. Any changes in the model, just as a general proposition, take a long time to accomplish. It's a deliberative process with a lot of input from various parties. So any kind of undertaking to change the laws nationwide, I think, would have to go through that NAIC process. To me, in that conversation, the starting point has to be the points that we've discussed today. What are the concerns? How do we address concerns that some players might inappropriately use the existence of the fund for sales that aren't in the best interest? What about the complexity of these products? How do we explain them? So the conversation would have to absolutely seriously consider those points and others, but I think a foreseeable outcome would be something that appropriately protects the consumer and the solvency, but doesn't have what frankly is a gag rule on the ability to talk about it with consumers for companies and producers. That would be my bottom line.
Yeah, well, thanks. Well, hey, Ramsey, we're at the top of the hour here. The final thoughts, questions?
It's a delicate issue, and I think at the end of the day, it's going to be up to the regulators to decide, what the right balance is. And, with input from the industry, that, again, around a best interest framework, I think is a very good way to do that.
I like that.
Ultimately is not talking about it in everybody's best interest, especially the client, or is really, really finding a very specific way to communicate it in the best interest. And if so, how does one do that in a way that works for everybody involved? So I think that's a worthwhile goal.
Yeah. Hey, well, listen, Bruce, Harry, thanks so much for joining us. What's the best way? People want to contact you or reach you, and work with you on this particular topic. What's the best way to get in touch with you?
Yeah, and people can reach me at financialverse.com. Just go right to my website and just I'll fill out the contact form. I'll get right back to you. But financialverse.com.
When we'll put that link in, including the books. You've written a great series of books that I think advisors could give to clients. And Bruce?
Yeah, I haven't established a website, but I'm always reachable at my email address, which is brucesaul@comcast.net.
Okay, excellent. All right. Well, listen, thank you all. Thanks for joining us. And as always, give us feedback and suggest topics we should talk about. And join us again next week for another episode of That Annuity Show.
Thanks for listening. If you've enjoyed the show, please rate and recommend us on iTunes, Stitcher, Overcast, or wherever you get your podcasts. You can also get more information at thatannuityshow.com.